Why is it hard to challenge grand jury evidence? Imagine being called to testify in a process where you have little say and no control over what's presented. That's what happens in a grand jury hearing. It's a secret meeting where prosecutors decide if there's enough evidence to move forward with criminal charges. But why is it so tough for someone to challenge what's presented there? Let's break it down. First, the grand jury process is mostly controlled by the prosecutor. They decide what evidence to show and which witnesses to call. The defense team usually isn't allowed to be there during the proceedings. They can't cross-examine witnesses or object to evidence as they would in a trial. This one-sided setup makes it hard to question or challenge the evidence early on. Second, the rules of evidence are much looser in grand jury hearings. Unlike a trial where evidence must meet strict standards for reliability, hearsay and even scientific evidence can be admitted without much scrutiny. This means the prosecutor can present information that might not be allowed later at trial, making it harder for the defense to challenge it at this stage. Third, the standard for issuing an indictment is low. The grand jury only needs to find probable cause, which is a reasonable belief that a crime was committed. They don't need to prove guilt beyond a reasonable doubt. Because of this lower bar, even weak or circumstantial evidence can lead to an indictment, leaving little room for the defense to argue that the evidence isn't enough. Fourth, defense attorneys often can't access the transcripts or recordings of the grand jury sessions unless a court orders it. Without these records, it's difficult to spot mistakes or falsehoods in what was presented. This lack of access makes it harder to file motions to dismiss based on flawed evidence. Fifth, courts are usually hesitant to dismiss an indictment based on grand jury evidence unless there's clear proof of misconduct or false evidence that influenced the decision. Such dismissals are rare, which adds to the challenge of challenging the evidence at this stage. Finally, most of the opportunity to challenge evidence comes after the grand jury has already issued an indictment. During pre-trial motions and the trial itself, the defense can contest evidence more thoroughly. But by then, the case has already been set in motion, making early challenges difficult and less common. All these factors combine to make challenging grand jury evidence a tough task. It's why many see the grand jury as a kind of rubber stamp for prosecutors. Defense attorneys have to work hard to find procedural errors or constitutional issues, but success is rare. Instead, they often focus on fighting the evidence during the trial, where the rules are stricter and the process more open.